Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
And welcome to all of you, the approximate 650 of you who showed up on time today, which is amazing. We're going to be talking about courtroom decorum, and showing up on time is key. You'd be amazed. We can get 600 people on time within a few minutes for our online stuff. But, you know, tell me how many times you go to court and all the lawyers are there on time. It's probably zero. So we're really looking forward to spending some time with you today and tomorrow. I know it's a long time, 3 hours each, and you're probably dreading it, but don't dread it. We're going to have a good time. This isn't going to be boring. We're going to talk a lot. We're going to interact. I'm here with my senior trial counsel, Michael Solomon, who is known as Solly. And so you'll hear me referring to him that way, and I'm sure you can as well. So happy to have Solly here. And I'm going to let Solly introduce himself in a moment. Most of you have probably either met with me or gone through some of my programs before. So I just want to go over some of the agenda for today and sort of what the sort of ground rules are for the program today. So it's going to be 3 hours. Each hour, we're going to cover a different topic. The first hour, we're going to cover courtroom and fundamentals of going to court, all that sort of stuff. The second hour, we're going to talk about depositions. We're going to talk about case intakes and investigations. And in the third hour, we're going to talk about legal research and writing. So we're going to talk about different aspects of all that. Tomorrow, at the same time for 3 hours, we're going to talk about deposition and discovery basics in the first hour, then basic trial skills in hour 2, and then basic trial skills again in hour 3. So that's what the program is. The materials are here. Michelle just put you the link in the chat. If you don't have them, you don't need to look at them. You're welcome to, obviously, if you're sick of looking and listening to Solly and I. But there's several hundred pages in the materials for today, and there will be tomorrow. We tried to, Solly and I compiled what we thought would be really helpful, and samples of pretty much everything we're going to talk about today and tomorrow are in there. And we'll screen share the ones that we think it's important to, look at with you. But another reason to be glad we're not in person, because Michelle and her team would have had to have printed out all the materials for everybody, and they would have been huge, and nobody wants to schlep around all those materials. So now you could just put them on your computer and save them as you need. Questions. Please, please, please ask questions. There is a Q&A at the bottom of your screen. You don't have to wait. When a question comes up, please type it in. Solly and I will be monitoring your questions. We love questions. That's why we're here. We're here to help you and answer questions that you have, even if we don't address it in our presentation. We want to make sure we cover what's important to you. So please ask your questions. We will try and answer some as we go along. If not, we're going to reserve the last 10 minutes of each of these hours today to just focus on questions. So just throw them in there. The other thing is that you can put into the Q&A comments. If you think we're wrong about something, put it in there. If you have something to share, put it in there. I'm not sure if everybody in the program joining us today are all newly admitted. There may be lawyers who have had a lot of experience and aren't as newly admitted that may want to give their feedback and share their experience. So I've been around a long time practicing law. Most of you know I'm a second generation trial attorney. Smiley and Smiley was founded in '68. My dad, Guy, founded it then, and I basically grew up doing this stuff, and I went right out of law school right into it. So I've been practicing for 30 years. I've seen a lot. So what I like to do in these CLEs is just share what I've come across. Solly, I'm going to let you introduce yourself now and share with everybody just a little bit of your background so they can put it in perspective for when we're talking about what we're going to be talking about today and tomorrow.
Sure. Well, welcome everyone. And like Andrew said, any questions you have, please feel free to put it in the chat. And if there's something we didn't address, then follow up with us after. We have our information. Please email us, reach out to Andrew, do a one-on-one with him for the mentor program. But just to give you a brief overview, my name is Michael Solomon. Like you said, people call me Solly, so feel free to call me Solly. And I was a former prosecutor in Brooklyn for the first 5 years of my career. I was thrown into the fire and standing on my feet and thinking on my feet for whether it was regular court arguments or trials or hearings or whatnot, grand jury proceedings, to now coming up on 6 years at Smiley and Smiley, and had a unique start to my career at Smiley when the world shut down, but that's for another time. And just sharing everything that I've learned in the last 10 plus years, let alone the last 5 plus years at Smiley and Smiley, and how we do things. And obviously, as Andrew said, not everything we say is going to work for you, or you may have other ideas. So please share so we can have a collaborative effort to see what works for everyone.
All right, great. Thanks, Solly. All right, so let's kick it off. So the first thing that we want to talk about today is going to court, right? What's that all about? You're a newer attorney. Probably you're going to get sent to court. And you probably want to go to court, and you should want to go to court because that's one of the reasons you decided to become a lawyer, right? Probably didn't decide you want to become a lawyer just to sit in an office. Maybe you did. But most people like to at least go to court, check it out. It makes you feel like a real lawyer to dress up and go to court and represent somebody in front of a judge. So you're going to be going to court, and most likely you're going for one of several reasons that we're going to cover. You're going there for a preliminary conference or a compliance conference. It may be a motion that you're going to court for. You may be going to court just to secure an adjournment of some matter. You may be going to court because the judge told you to be there to talk about the case. And you're being asked by your law firm, your boss, your partner, your supervisor. You're told you need to go to court, you need to cover this. They give you the file and they tell you to take care of it. So they may not have told you much else. And that's what we're here to try and fill in the blanks about what it's like when you go to court, things that you need to think about and that you may not. And these are the types of things they don't teach you in law school, right? They really don't have a class on how to dress for court, how to act when you go to court. So first thing that I want to chat about is something that I feel is extremely, extremely important. I'm a big believer that this is a profession and we need to practice as professionals, okay? Everybody worked really hard to get their law degree. We all did. And that gives us a certain level of professionalism that we're expected to have, that we've gone through all of this. We go to court, and when you go into court, that is a sanctuary. You know, it's as if you're a religious person and you're going into your house of worship. That's the equivalent. If you're a lawyer and you're going into a court of law, that is what we've trained for. And you shouldn't take it lightly. People are going to look at you, whether it's your adversary, whether it's court personnel or the judges or other clients or people just sitting in the courtroom for various reasons. And eyes are on you, and you need to be aware of that. Most courtrooms have cameras in them too, and clerks behind the scenes are watching what's going on. So first off, dress appropriately. And what do I mean by that? Unfortunately, men and women, through norms, and it's none of my place to talk about it, but we all have different uniforms that we wear to dress up for court. Men wear suits. Women usually don't wear a suit and tie, but they will wear other appropriate clothing, whether it's a pantsuit, whether it's a skirt and a blouse and a blazer, or whatever you may wear. But whether you're a man or a woman, you need to dress like you're going to court, like you would dress if you're going to a very formal engagement somewhere, like you would dress if you're going to, meet a judge. Okay. So for men, suit and tie, always. Do not show up without a tie. Do not show up without a suit. Preferably, it's good to have a suit and not just a mismatch that you grab from your closet. Make sure your shirt is tucked in. Make sure your belt is buckled. I can't tell you how many times I've gone to court and I sit there in the courtroom and I see lawyers getting up, male lawyers, that have their shirt tails hanging out the back of their clothes, that have their tie askew and their shirt open, or they don't have a tie on, or they look like they just got dragged in off the street. It's unacceptable. Make sure before you go to court, you always have clean clothes to wear, clean suit, clean shirt, nice tie. dress nicely, be buttoned up, be professional and respectful. If you're not, what kind of message does that send? What does it send to your adversary? What does it send to the judge if you show up looking like you've just rolled out of bed and you're hungover? Okay. It doesn't look good. You're not going to get respect. You're not going to get credibility. You're not going to be seen as a professional who's serious about his case and his clients. Same thing for women. Dress appropriately. All right. And I'll leave that to you. I'm not a woman. I can't tell you what to dress, but I can tell you that if I look at you and you come into a courtroom, I could tell the difference between someone who's dressed appropriately and someone who's not. Show up and be dressed like you care and you're representing somebody. Because if you're in a courtroom, you are representing somebody. You have a client. You have a law firm you're a representative of. If I found out that Solly was seen in court without a tie on or his shirt hanging out, or he didn't look well, or he wasn't handling himself well, that's a reflection directly on our law firm. I will not be happy with that. The client may not know what he was wearing, our client, but I will find out and I won't be happy. I want any lawyer at Smiley and Smiley shows up in court, they're going to look the part. They're going to look professional. They're going to look like they know what they're doing, like they're prepared. Okay? So that's just simple starters. Solly, I'll allow you to chime in on that before we continue on.
No, I think it's pretty self-explanatory. It's, it also, if you feel the part, you're going to, look the part, you're going to act the part. So it all goes in hand, and we can get into this tomorrow in part 2 when we talk trial skills. Your courtroom outfit may change depending on the trial venue you're in and the type of jury, the pool of jury. You don't necessarily want to be as flashy, or you want to be under the radar, because if people start questioning your outfit or the way in which you're the information is being received by the judge or the court, and it feels like you're being treated a certain way because of how you're dressed or how you're appearing, well, then you're already behind the 8 ball and you're doing something wrong, because it's not about you, it's about your case and advocately representing your client. So you need to have suit and tie, go to court, and everything else will fall into place.
Great. Now let's talk about how to talk when you're in court. First of all, if you're in the courtroom waiting for your case to be called, and we're going to talk about how that all works in a moment, but if you're in a courtroom and you're sitting there waiting, usually there's going to be, you've got where the judge sits up front, you've got the jury box, the witness stands to the side of the judge, where the court reporter sits. Then you'll have a counsel table or tables. If it's more than one table, they'll either be side by side or one in front of the other, and some chairs. You may see a podium in there. And then there's going to be sort of a barrier, a banister behind that. And that's actually the bar, if you didn't know that. When you talk about passing the bar, the idea is that only lawyers, unless you're being called up as a witness, only lawyers are supposed to be in that front area. Okay, you've passed the bar. So that's a nice little tale there of what the bar is. But before you get called up on your case, most likely you're going to be sitting behind where the audience or viewers sit in the benches or the rows of seating. So when you're sitting there, if you're going to be on your phone, make sure the phone is off. Okay. Sometimes some court officers will yell at you if you're even looking at your phone. But of course, we're sitting around, we're bored. Sometimes we're checking emails, messages. It's okay to have your phone, keep it in your lap, keep it off, be respectful, be alert, be aware of who's around you. Now, when you're interacting with a judge, always be respectful, always stand up. I hate when lawyers sit down at the table and the judge is on the bench and they stay seated. When a judge enters or exits a courtroom, you stand, whether it's a trial or not. When you are being asked to give your appearance, which means step up and say who you represent, what law firm are you from, what your name is and address, and Solly's going to walk you through how to give your appearance in a moment, you stand up. Whether you're on the record, which means the court reporter's taking it down, off the record, whether there's nobody in the courtroom but you and the judge, you stand. Unless the judge says, please, counsel, sit down. Okay? You stand. It's a show of respect. And that'll continue on any single time you're in a courtroom, and especially when you get into trials and trial skills. Objecting, speaking to the judge, you always stand. You never sit back in a chair. judge, judge. And you don't use the word judge. Your Honor. That is the respectful way. So you stand up, yes, Your Honor. You sit down, thank you, Your Honor. No judge this, judge that. That is very comfortable language. That is language that you may hear older lawyers talk about. It's still not proper. I will never say judge, judge. It's always Your Honor. I even have friends who are judges. And when we're in public, I refer to them as Your Honor. Okay. When I'm in private, I could call them by their first name. It's a matter of respect. So be dressed, be buttoned up. When you stand up, make sure you're buttoned up, your blazer's buttoned. Okay. Don't have things in your hands. Be organized. Show the judge you're there, you're respectful, and you're on time. Now, Sally, can you share with everybody the proper way when you show up in court and a clerk, a court reporter, or a judge says, counsel, please give your appearances? What do you do?
Sure, I would stand up, make sure my suit is buttoned, and I would say, Michael Solomon from Smiley and Smiley on behalf of the plaintiff, good morning, Your Honor. And if you want to address everyone in the court, good morning, Your Honor, and court staff, you can, but good morning, Your Honor, and that hits the ground running, it sets the tone.
Exactly. Always do that. Good morning, Your Honor. Good afternoon, Your Honor. My name's Andrew Smiley from Smiley and Smiley. I represent the plaintiff. Sometimes the court will ask you to put your address on the record for your firm. You can do that. They want to know who you represent. If you have different, usually it's only one plaintiff or plaintiffs represented by a firm, but there's oftentimes where there's multiple defendants. So if you're representing the defendants or one of the defendants and you stand up, good afternoon, Your Honor. My name is Andrew Smiley, and I represent defendant Acme Corporation. Okay, let them know who you are, who you represent, and I'm from Smiley and Smiley, and what law firm you're from. Okay, very simple appearances.
And I'd even say, have a business card ready because you know the stenographer is going to want it. Don't just breeze through your name and your firm because no one knows who you are, even if you think they do. You know, Andrew Smiley sending me into court, he's not going in. But, you know, their court reporters are entitled to that information. And if you treat them with respect as well, those are the people who are writing down everything you say and can make you sound bad or clean up some of the ums and the ends. So you just want to be respectful and have everything buttoned up. So you're a well-oiled machine. You know exactly what you need to say and you know exactly what you need to do. And it just, optics are everything. That means a lot.
When you go to court, be prepared. Full stop. Be prepared. If you've heard me present or on my podcast, what do I say? Preparation, preparation, preparation. That's it. Preparation is the key to what we do in everything as lawyers. Preparing for a deposition, preparing for trial, preparing for court, preparing for an appearance. You need to be prepared. Don't just grab the file and show up at court. We've all seen people who do that, and it's not acceptable. You need to anticipate what the judge is going to want to know, no matter what you're going to court for, whether it's a conference, a motion, a pre-trial, a settlement conference, whatever it is. You need to know the underlying facts of the case that you're there for. You need to know why you are there, what the issues are, and you need to have answers. And you need to know if you're showing up buttoned up, you've complied with all the deadlines, you've done everything expected by the court, or whether everything's not buttoned up. And sometimes it's regardless of fault, you know, Sally may show up on a case and the judge may say, why wasn't this deposition held? But maybe it wasn't his case and he doesn't know why it was held or he had nothing to do with it. Well, he needs to find out. He needs to reach out to the office. The judge is going to want to know, what did we do these depositions? Why did we? Why didn't we? Was it our fault? If it was, I'm going to apologize to the court and say it was an error. There was an issue. We're working to get it rescheduled quickly. If it wasn't, then say why. But you need to know what you're there for, and you need to be fully prepared. Because if you're not, you can't show up and be like, oh, it's not my file, judge. No, you don't do that. There's no easy outs. That won't fly. And it may fly with some judges, but you get in front of a judge who you're not prepared, and you could be in some serious trouble. And they're going to remember that. And then when you need that favor, that adjournment, that extra time, that motion that you want them to compel something, you want them to do something, they're going to remember if you're that lawyer that's always prepared and buttoned up from that firm that's always prepared and buttoned up, or the other. Okay. So make sure you're prepared. And there's different ways you can always be prepared. Sally, you want to share how you make sure you're prepared for court?
Absolutely. So I'll go over a list. I'll have a legal pad, and I will write down the name of the client. I will write down the age. I will write down the age of the client at the time of the accident date. You have to start to continue to relay these facts in your mind so that this case becomes ingrained in your brain, so that if you did go to trial, that you've already put the groundwork in at a PC conference, at an initial conference, that you already have. This is an accident that took place July 24, 2020. The client was 62 years old. You know, the court always wants a one-liner. What is this case about? Is it premises? Is it motor vehicle? Your Honor, this is an elevator accident that took place inside of a Marriott hotel when it dropped from the fourth to the second floor, and, you know, after conservative treatment. The injuries, the damages, the treatment, the demand, if there's an offer, these are easy layups that the court wants to know. And when you're just stumbling over your words and not, you know, up to date on the case, like Andrew said, saying, oh, well, I'm handling this case for another colleague. You can't use that line. You have to call that colleague and get the answers. When you're riding the train on the way to court, look up the case and write notes in your phone app, or write an email to yourself. If you're driving and you can't look up that stuff and you didn't do it the night before, call a colleague in your office, call your secretary, your paralegal. Hey, do you mind just running through this case with me? Can you send me an email with all of these details so I am, you know, prepared? And you get to the courtroom, you're waiting for your case to be called, you pull up the email, you have it all there. So if you lay the groundwork, now I'll say one thing, Andrew, in addition to being prepared, there may be a time when you're asked a question during a court conference where you don't know the answer to, and you don't necessarily know what that partner or what that other attorney, if you're covering it for them, or if it's your own case, necessarily what to do. And if the court is pressuring you, my experience is, and it could be intimidating and it may not work, is call a timeout on the field. Your Honor, before I make any move whatsoever, you know, I know the court wants an answer. I'm going to ask if we could just briefly second call. I don't want to necessarily give an answer. I'd like to just discuss with the colleagues or my firm, and you know, come right back. If the court says no problem, we'll grant a brief second call, make it quick, counsel, go outside, make the call, get the info, come back. And if that's just not the case, then you're going to have to make a record and kind of do the best you can with what you have. And just know everything, most everything in this practice is fixable, or there's a way to work it out. But I don't know what your take is on that move. Obviously, you know, you make the decision, so you go in knowing, but there's times where you may not know, and that might be a way to handle it.
Attendance code number 1 is NEW 128. That's NEW 128.
Yeah, I mean, it's not uncommon that I'll get a call from Sally from court, either on a short break or, yeah, we met with the judge sent us out, wants to speak with defense counsel right now. What do you think about this? The judge is proposing this. Should we agree to that? Should we not? What do you think? So there's nothing wrong with that. Don't feel like, you know, if you work for somebody, don't feel like you shouldn't call them because it'll show that you're not competent. You know, that's a big issue that I think younger or newly admitted attorneys have, is they're afraid to ask too many questions. And I don't think you should ever be. And if your employer doesn't like that you ask a lot of questions, then they're a bad employer. Okay. It's our job as the senior people to make sure that the newer attorneys in our firm, or any attorney that we're sending out to war for us, has the artillery, has what they need. And if they're calling you because they need some feedback, you have to give that to them. So don't be shy about taking a break and making a call if you have to. Your Honor, I want to get this done. Can I just make a quick call? And judges will get it, especially if you appear as a newer attorney. You could say, it's my first month on the job, Your Honor. I don't want to mess up. Oh, no problem, no problem. I remember once when I got sent to court in Brooklyn as a new lawyer 30 years ago, and it was on a conference, and we hadn't completed certain things, and somebody in my firm at the time had dropped the ball, totally didn't do something that they were supposed to. And I showed up for a compliance conference, and the judge is saying, why wasn't this done? Why wasn't that done? And I was like, I don't know. And I just got admitted last week. So he smiles and he goes, oh, so I guess you're not the first name Smiley. It was even before the firm was Smiley and Smiley. It was Smiley, Schwartz, and Captain. And I'm like, yeah, no, that's my father. Ah, I got it. So they sent you in here to take the hit, huh? Nobody wanted to come themselves. So judges get that. They'll get it if you're new and you're being thrown into the fire. But it has to be because you were truly thrown in, not because you weren't properly prepared. Ultimately, what does a judge want? A judge wants these cases to move. They want answers. They want to find out what's going on. And if they see that you're working hard to do that and get them the information they need, they're going to respect that. And they're going to respect if you're being truthful. Don't lie. If you know something, share it. If you don't, you could say, I don't have an answer, Your Honor, but if you give me a few moments, I can get that answer for you. Okay. I will work to get that and get right back to you. That's what a judge wants to hear. So keep that in mind. Keep that in mind. And no grandstanding. If you're in a courtroom and there's a lot of people in the back, don't feel like you have to act a certain way other than being respectful and prepared. Okay. Now, to keep moving, because we only have a half hour left and we still have a decent amount within this area to talk about. Generally, the conferences, as I mentioned, you're going to go to two of them, the preliminary conference, which is called a PC in our world, and a compliance conference called a CC in our world. The PC is usually the first conference that will be taking place in any type of litigation. And sometimes you have to go in person. Sometimes you can work out an order amongst yourselves. It's going to depend on what the judge or the judge's part rules call for. And I'm going to ask Sally in a moment to explain to you how you find that out. But you're either going to work it out with your adversary in advance, fill out the form and file it, or you're going to show up in court and work it out in court and meet with the judge or the judge's legal secretary or law clerk. Sometimes those names are interchangeable. Frankly, I'm not too sure of the difference. Sometimes the law clerk is the attorney in the courtroom dealing with stuff. The law secretary is an attorney who works in chambers with the judge, working on their briefs and motions and decisions and all of that. But you'll either meet with the judge or the law clerk or law secretary to go over, or they may just ask you to submit it and then they'll stamp it and give it back to you. That's the same for a preliminary conference. The preliminary conference, Sally's going to share with you, basically goes over, it's like a management order in federal court, a case management order. When are depositions? When are demands due? When are responses due? When are IMEs due? When should discovery be complete? Those types of things, okay? The compliance conference is when you go back to court to see if all these things have been complied with. Sally, I'll let you take it from here.
Yep. So when just to jump back for a quick sec, when a complaint is filed, a party then answers the lawsuit, you have both parties on board, then you're going to do a request for judicial intervention, which is in our materials. And then that's going to let the court know, and then you're going to request a PC saying we need this preliminary conference that Andrew was just saying. And then here's a sample PC from a case that we are working on currently, the standard track instead of expedited.
E is expedited, S is standard, C is complex.
Right. So there's different guidelines for each of the expedited, the standard, and the complex. So the court is telling you which one, and then basically they're laying out when deposition should be conducted by, when you need to, shall be served on or before 15 days from the date of this order. So what you need to do is, however you do it with your firm, you need to either keep a spreadsheet, you need to keep lists of these dates, you need to put them in your calendar so that you know when these deadlines are coming up. When depositions need to be conducted by, and so on and so forth. And then when the end of disclosure, so no more discovery, and when your next conference would be held. Now, again, the court wants you to adhere to these guidelines, but sometimes more treatment gets in the way, which you need another deposition or things get delayed. So that's where you have to work with your adversary to make sure that, here it is spelling out the different parties, the different dates of these depositions. I will tell you that none of these depositions took place on any of these dates, and that happens. And it's just, hard for the stars to align. And then this is the compliance conference. You'd go to court, you'd fill out what's called a stipulation. You'd work out everything that's outstanding, and you'd go and you'd have it signed by the judge. And then this is it. And then you'd go the next time and you'd have another list of things that need to be worked out, and so on and so forth. And it keeps letting the court know that you're working on it. So this is exactly, and then the judge's rules, Andrew, if you want me to go forward on this.
Yeah, so what we're going to talk about is, so here, that preliminary conference order you saw is one that the court issued directly on their own.
Yep.
And as opposed to sometimes they'll give you a form to fill out with your adversary. So that's one where they did on their own. But when you work it out with your adversary, I would just say, someone start, take the lead, put in all the different dates. I think that defense usually wants longer dates further out for depositions and things. Plaintiffs usually want it faster and sooner. Just try and work with each other, try and compromise. This is usually the first time you're going to interact with your adversary. So it's probably good not to piss each other off and be too rigid, knowing you're going to need to work with each other. And probably you're going to need a favor, they're going to need a favor. You're going to need adjournment, they're going to need adjournment. So try and work it out.
Yep. Exactly. And then, each court, when you're assigned a judge, you go to Google, you type in the court part, you type in the judge, it'll pull up their rules, and you'll save this set of rules to your file. So now you know that this judge and these rules are what they require. And you need to make note of the different rules that this court has and how you handle adjournments and how you handle motions and how you handle different conferences. This is the guideline, so don't be calling the court, don't be calling chambers, don't be calling the court part. They're going to say, did you read the rules? And if then after reading the rules you have a question, that's when you can reach out to the court or maybe your adversary to say, hey, what are you reading this rule as? So you have to work together on this.
That's great. So we could stop that chair for a moment.
Sure.
And I think that's a really important point, that lawyers, experienced and newly admitted, don't look at judges' rules before doing something. And then they get sanctioned or they don't get the relief they're seeking solely because they didn't take a moment to review the rules. So what our firm does, as Sally said, is once we get assigned a judge on a case, we Google that judge, we Google for their rules, we download and we save them in our file. So we have them. So then when an issue comes up, you check the rules. If you get a call from your adversary the night before the deposition that you expect to go saying we can't do it, we've got to adjourn it, you say, look, the judge's rules say we can't adjourn it, we'll be sanctioned unless we notify the court. So I'm not just going to agree to adjourn it, but what if you do agree to adjourn it and you haven't read the rules? And then you show up in front of that judge. Mr. Smiley, you didn't comply with my rules, did you? There's no worse thing than to have to say, I'm sorry, Your Honor, I did not comply with your rules. Okay. So they're available. There's local rules for the court. There's local rules for judges. It's the same if it's in state, if it's in federal courts, you're going to have a district court judge is going to have one set of rules and a magistrate judge is going to have another. And I had a situation earlier this year where in federal court, where I went to file and did file a summary judgment motion. And before filing it and knowing that summary judgment motions go to the district court, I checked. I said, do we need to do anything before filing? And there was no rule that you couldn't file a motion when you're ready. So we filed it. So then we have a conference call with the magistrate who proceeds to reprimand me for not complying with his rules that require a letter and a conference beforehand, to which I pointed out to the judge that there have been new parties that have joined who did not consent to his jurisdiction for these types of summary judgment decisions and motions, and that it goes to the district judge, and that the district judge didn't require that. And he apologized to me. I had a magistrate judge say, I'm sorry, Mr. Smiley, you're right. We got to get that squared away first, because right now I'm not assigned to handle this. So you need to know your rules. There's no excuse for not knowing them. All right. So,
yeah, and Andrew, I think that this goes into one of the questions, and we can just run it briefly. Is someone had asked, how do you respectfully interrupt the judge if you feel you're left out or not been heard on something, or something is wrongly recorded? And as Andrew just said, exactly that. You wait for your turn, or if the judge looks like they're ready, Your Honor, may I have one moment? I'd like to just put one thing on the record. No, counsel, we don't have time. enough said, or yes, make it quick, and then you make your record respectfully, and you do it, and you're not telling the judge that they're wrong. You're just saying, maybe I misinterpreted the rules, or maybe I got it wrong, and then let the judge then make the determination whether you're wrong or right. But that's a good way, I think, that you can handle that.
Yeah. So what Solly's talking about when he talks about making a record is having something recorded by the court reporter who's in court when you're there. Sometimes judges will have things that they will discuss, and the court reporter, more likely than not, is not taking everything down. Some judges have everything on the record. A court reporter takes down appearances, everything that's said. So when you ask about making a record, or you're saying to the court, may I please make a record, or I would like to make a record, you're saying, I need to document what you're saying and what I'm saying to protect myself for issues of appeal, for going back to my boss, for whatever it may be, for my client, for whatever, for motion practice. And judges get that. They get that even if you disagree with them, that for you to do your job properly, you have to make a record. You have to protect yourself. And they're not going to fault you for wanting to make a record. They may not be happy sometimes if they think they're writing you're being a pain in the ass, but they have to let you do it. And if they don't, that's a problem. You can go above their head to the administrative judge and just make your record. Say, well, I'd like to make a record that I couldn't make a record. No, there is no record being made. And then look, you're stuck if you're stuck. But as far as interrupting a judge, you generally don't want to interrupt a judge ever. Now that I've been practicing longer, sometimes I'll give it a shot if it's really, really important. But generally what you have to think about is you have to weigh your advocacy for your client and your firm and the respect for the judge and the judicial system. And it's a tough dance sometimes. But if you have to make a point, or if you have to point out a judge is wrong, you got to do it. So what you want to do is you're going to wait your turn. Sometimes you've already gone and your adversary says something and the court says, all right, well, I've heard everything. You say, oh, Your Honor, if I may, please. Yes, Mr. Smiley, what do you want to say? So that's what you do. You just, when the time comes, Your Honor, if I may. Your Honor, can I just can I state one thing? Your Honor, can I bring something to the court's attention? Your Honor, I'm sorry. Can I point this out? That's how you do it. You do it respectfully. Your Honor, I understand the court's ruling, but may I have leave to make a record of? All right, we've got about 5 minutes before we're going to go to address all these great questions. Solly, why don't you talk to everybody about e-filing? For those of you who don't know yet, probably 95% of cases now are required to be e-filed, which means from beginning to end, from your summons and complaint, everything goes through the court e-file system. It's either state court or federal court. State court, you have e-courts. Federal court, you have the PACER system. You need to have logins and access. You need to familiarize yourself with that. You need to learn how to e-file things, and you need to comply with all e-filing requirements. Solly, why don't you share with everybody a little bit about the e-filing process, and then you got 4 minutes.
Yeah, so this is NISF. This is where you're going to file your state cases. If you were filed a complaint and there's an answer and you did an RJI, or request for judicial intervention, you're going to get what's called an index number. That index number is going to be the number that identifies the case.
Solly, how do you get to this link? What's the website for this?
Yeah, so you're going to go to, I don't know if it's up here, hold on. It is, because I have it saved, which is good. You should have a bookmark saving it. And it's going to be, give me 1 second. It's going to be iapps.courts. Here, do this.
You put it in the Q&A, the chat. You could drop it in the chat. And I think you can also go to ecourts.gov, which might get you there as well.
Yeah, so you can play around with it, but here you would show them. You go here, you put in your credentials, you log in, and then essentially on this side of dropdown, then you'd be able to put in Supreme Court. Either you can search a case, and you could search it by the index number, you could search it by the party's name, first and last name. Or if you're looking to file something, then up here where it says file documents. Are you seeing this, Andrew?
Yep, I'm seeing it. Perfect. Yep.
Then you go to Supreme Court and then file to an existing case, start a new case, and you would just navigate through that, find out the court, the county that you're in, so that you're making sure that everything is correct. And you'd follow the prompts, and you just keep following the prompts. And as we showed from the materials, as I will just pull it up quickly. Then when you're ready to file something, whether it's a motion, whether it's a document, an order to show cause, it's going to have the index number, it's going to have the county, and then it's going to say, are you filing anything that's redacted or unredacted? Meaning if there's any pertinent information that you don't want e-filed, like social security numbers and whatnot, you need to make sure that it's redacted. And then there's another drop down here to say if things need to be redacted or not. And then here, says the case name, and then are you filing a request for judicial intervention? That'll start the process. Yes. And then you're checking off whether it's torts, motor vehicle, and so on and so forth, and following these prompts. It's pretty self-explanatory, but that's where you need to rely on your support staff, and you need to rely on other colleagues in your firm to say, hey, can you walk me through and have a one-on-one one day and just sit down and e-file a case together? The only way in which you will get good at this practice is if you do everything. Whether you are able to e-file something, to write a summons and a complaint, to go to court, like all of these skills will make you a better attorney and a more well-rounded attorney. Because even as you progress in your career, you may not think that you want to do those things, but you can do those things, and it may help the firm if you're able to do it quicker than maybe your support staff who is busy catering to all the other attorneys in the firm.
All right, great. Thank you, Solly. Yep, e-filing is just a matter of getting used to it. There's a lot of drop-down menus, especially in federal court. Everybody always will file under maybe the wrong thing. You know, when it's a motion, but it's a letter motion, it should be filed as a letter motion, not as a motion, things like that. And the courts will be quick to tell you you made an error and it's returned and refile it. The federal courts are very helpful and friendly. If you call the clerk's offices for any federal court, especially help with filing issues or whatever, they can sometimes just fix things for you if it was filed improperly. State, Supreme Court, civil court, state courts, generally not so friendly, and you got to figure it out yourself for the most part. But yeah, don't be afraid to ask other attorneys in your firm, paralegal support staff. We have our main paralegal, Madeline, is amazing, and she files a lot of stuff for us, so she knows it really well, but she'll still reach out if there's a confusion or an issue. But get to know e-filing. It's super important. All right, we've got 10 minutes left. We got some great questions. Some of them we've answered or I've typed in an answer, but now let's go to some live questions because I like the first one that I have ready to go live, which is from Michael Marolda. Wants to know, what happens when Cousins wants me to try the case then and there? Well, I don't think he's going to be on the bench too much longer. Isn't he retiring, Solly?
He is.
Yeah. So if he tells you that, just tell him you're a friend of Solly's and he'll give you an adjournment. All right. So don't worry about that. But in reality, look, that happens sometimes. I don't think as much as it used to, but I've been sent to court back in the day for a pre-trial, and I've been told, don't worry, nothing's going out. They're going to kick it over for at least 3 months. And I show up and the judge says, put the slip in, let's go get a jury. And I'm like, what? And you start sweating big time. So what do you do if a judge tells you go start a trial and you're not prepared? You're honest with the judge and say, Your Honor, and whether you want to do it in front of court or adversary or ask to approach the bench or whatever it may be honest. Judges don't like bullshit. They don't like, think about how many excuses. I mean, if you've ever gone in front of a trial assignment part, especially in Kings County in the big room there, it's hysterical. You could write a book. You sit there all day. The excuses people come up with for why they're not ready to go start a trial are just, they've heard it all. Just be honest. And I've spoken with trial assignment judges about it. And they say, I hate when someone bullshits me. I hate when they lie to me. I'd rather them say, Your Honor, it's my kid's baseball game tomorrow. And it's a really important game. I really would like to see it. Can you just give me 3 days? I can see the game. I could get my act together. I'm really asking for the court's assistance here. They give it to you, they give it to you. If not, not. But you're better off doing that than coming up with some nonsense for an adjournment. All right. So, first of all, be ready. Do your homework before you go into a courtroom. It's helpful to go to that court before your case, the date before, or anytime prior. I recommend that for jury selection. Go look at what the jury part's like. If you want to see what conferences are like or how a judge runs their motion part. Every courtroom, every county, every state, every judge runs things differently. So either go there in advance to prepare yourself. You'll feel a lot more comfortable when it's your time to go, or find out a local lawyer in that area. Call up one of the per diem services whose job is to cover that courthouse and ask them what's going on. Are these cases being sent? Should I be ready to go? Will they send me out? And they'll tell you. And so you'll have that level. We still do that. I've been practicing law 30 years, and you ask me right now, yeah, we've got a case set to go out in the jury assignment part in Queens next week. I don't know if it's really going to go. I'd reach out to a colleague or call somebody. What's going on in Queens parts these days? Are they sending cases out? What's the deal? All right. So that's how you handle that.
You should be pretty close to, if you're at that part where you're before cousins, you should be pretty prepared up until that point. But I just want to say, and we'll get to another question, but one of the biggest nuggets that I could give you when handling courtroom decorum and whatnot is do not speak in elevators, do not speak in lobbies, do not speak on court floors. You never know who's in your elevator. You never know if it's an adversary. You never know if it's a court staff. You never know if it's a witness or a potential juror. Don't say anything in the courthouse. Don't say anything in the elevators. Don't be calling your boss that person, that, SOB. And next thing you know, the associate is sitting in the elevator, and you're now bad-mouthing the partner from that firm, or you're now, the potential jurors in your elevator. Just, you don't know who is who. Just keep your mouth closed. Do what you need to do. And then when you get in your car or you get on the, commute home, then you can make your calls. But keep it tight.
Yeah. And again, all eyes are on you. You don't know who's watching you. I could be in court for something, for a conference that I'm showing up on, sitting in the back, and I see some younger lawyers show up and give their appearances and be totally unprofessional or totally unprepared. And I find out that they're at a law firm that I know, whether it's plaintiff or defense, and I know the managing partner there, and I'm appalled. And I'm appalled at what I see. I may call up that lawyer and say, can you believe what your lawyer did in court today? You need to know this. So you don't know who's watching you. You don't know who's reporting back and who knows who, but I can tell you it's a pretty small world we're in here. And reputations will precede you and will follow you. You ask anybody out there about me, ask them about Solly. People will know and share with you what they know about us. And hopefully, and we believe those will be positive things you'll hear. But for those lawyers who aren't on ball or who are difficult or who are not prepared, it gets known really fast. All right. So there's two questions here that sort of overlap. Jacqueline and Tiffany. Jacqueline saying, is it different formality where you practice in comp law or criminal case versus civil case? Tiffany's asking, is it different formalities in federal versus state court? So here's how I'll answer that. My personal belief is you should be formal in any courtroom setting. I don't care if it's workers' compensation, federal court, state court, civil court, small claims court, court of appeals, Supreme Court. When I walk into a courtroom, I am buttoned up, prepared, respectful, and ready to go. I don't change how I address somebody, how I address the court, or anything. I'm always going to be holding myself and others to the highest level of standards. Now, is it true that if you go to traffic court or criminal court, it's going to perhaps be more casual, more routine, more redundant, more the prosecutors standing up? I mean, Solly, you've probably stood up in court, when you have a roster of cases, right? And you're the only one in court in front of the judge that day, and this and this and this. And yeah, does it get easy to get a little more comfortable, a little more casual? Yeah, it does. But should you? In my opinion, no. Never. Always bring your top game. That's going to separate you from others. It just is. In federal court, yeah, federal court is much more buttoned up than Supreme or civil court. When you walk in, you're probably one of only one or two cases on the calendar. A whole courtroom staff's going to come out. There's going to be video on you. Things are always going to be on the record. So the setting is more formal. Absolutely. Your behavior, though, should always be formal. That's my opinion, and I think that's the proper way to practice. All right. So there we go.
Questions about PC who request it. Well, the plaintiff would generally be the one requesting it because you want to get the case moving along. And if in order to get the case moving along and get that PC order, then you have to request it. So you have to be proactive on your cases. The judge will most likely, and the court will be determining what discovery track it's on. And with respect to how soon to file summary judgment motions if defendant defaults. Well, on an S&C, well, do you have a default motion? Because you should worry more about getting an actual default judgment against that defendant that is defaulted than, moving for summary judgment. You can't really move against a party that hasn't answered in a lawsuit. So you need to tackle one thing at a time. So first you would what's called file a default motion to get a judgment. And then from there, you may not even need to file summary judgment because you don't have anyone to answer or to oppose the motion, and the court is probably not going to grant it. So until this person appears in the case. So.
Yep. So who decides if it's expedited, standard, or complex? Generally, the court will. If they ask you, the fallback is standard. Complex will sometimes be a product liability, medical malpractice. Expedited is usually if you file for a special preference or you intend on it. You can get special preferences based on age, disability. There's certain other reasons if you look up what the basis is for a special preference. Generally, it's going to be standard. Generally, the court will decide. If it's left to the parties to decide, you should put standard unless both sides agree it's complex. And the practical difference is they're going to give you more time on a complex, shorter time on expedited, sort of normal time on the standard, if that helps make sense. All right. Is there any problem with using a laptop or tablet in lieu of a paper, pad, and pencil to take notes from counsel's table? Nope. I don't see any problem with that. Use what's comfortable with you. Solly, correct me if I'm wrong. I've never seen any court have any issue with people working on their laptops or their iPads, right?
Right.
Yeah, no problem at all. Do what's comfortable for you. All right. Where do you find the judge's rules again? They're just on Google? Yeah, it's easy. I mean, technically, if let's say you have Magistrate Judge Smith in the Southern District, what I would do is I would Google individual rules for Magistrate Judge Smith, Southern District of New York, and it'll usually pop right up. Or you could go to the Southern District's website. It's probably something like sdny.us.gov, something like that. You look up their website, then you go to the individual judges, then you look at the district judges, then you find your magistrate judge, then you'll find that magistrate judge's rules and other types of samples, which is always good to do. Sometimes they have a lot more than rules in there. They may have trial stuff. They may have, rules regarding in limine motions that are separate. So you always want to find those. But yeah, basic Google search should do it for you. All right. Robert Costante is asking, what can be done when courts continually allow your adversary more and more time to complete discovery? What's the point if they ignore it, if they're incompliant? In federal courts, if you miss a deadline, you read the Riot Act. Why is it so different? That's a great point, Robert. And in my 30 years of practice, nothing's changed. It depends on the judge. We've had some Supreme Court judges in New York who have given the business to adversaries and to parties in general who don't comply. I like that. Our firm in general likes federal court. Have you ever seen any of my series or lectures on venue and how to choose between state court like Supreme or federal court if you have diversity? We'll talk about that a little bit later on today. But one of the reasons I like federal court is because you get your discovery and you don't have to make motions. And I had a case once where I had to decide, I had two choices for venue in a bad injury, Supreme Court Bronx or Southern District Manhattan. Which would you pick? Well, what I had to weigh out was better jury pool, Supreme Court Bronx much faster in getting the discovery I need when I need it in federal court. So I went federal court, and that paid off because the defendants, it was a big case. They were trying to stonewall us every which way, and this judge wasn't having it. So it helped. So the answer to your question is you just stay on it. You make records. You show up at court, give a reason why they didn't appear. If there's a deposition, someone doesn't show up, you make a record of it. You make a motion to preclude. You make motions to strike their answer. Usually judges won't do it the first time, but if you make enough of a stink through papers and in your appearances, this is the third time we've come to court, Your Honor. They still haven't given us a deposition. We were asking for a self-executing preclusion order, which means that if they don't appear by December 31st and they don't produce a witness, they will be precluded, right? So you're always going to ask for that. Some judges will give it to you, some won't. Some will say if they don't, then that'll give you the right to make a motion to me to preclude. I know we're into the second hour already, but let's get through these questions for a little bit still if we can. So you just have to keep making your record. You have to make your motions to compel. You have to stay on it. And that's all you can do is keep fighting the good fight. But it's one of the frustrating things we do in our practice is we have to keep pushing. It's more common, unfortunately, than not that you don't get the discovery you need, whether you're a defendant or a plaintiff, and you just have to push for it. Go ahead, Sally.
Yeah, and just lastly, and then we can go on to hour two of part one. But Kim Kohler reminded me, who's on the associate board, that Judge Cousins, we created through the Academy's associate board something called special term. A few of the colleagues from our board created it a few years back, where we live stream summary jury trials. This is in fact the last summary jury trial that Cousins is putting on before he retires. So that more details will be to follow, but on Wednesday, December 10th, you should tune in. The links will be available through the Academy, and we'll be live streaming it onto YouTube so you can see that trial. So that's another way to gain access into the courtroom, to observe other people's decorum and how they handle themselves, and how what you might do differently, or things that work for you and things that don't work for you. So stay tuned for that.
Attendance code number 2 is NEW131. That's NEW131.
All right, a few more questions. Let's keep going with these because, like I said, we're here to help you, so we want to answer what your questions are. So we'll still get through all the materials planned for today, so don't worry. All right, so Andres is asking, what would be a good way to reach out to the court with inquiries whenever the judge's part rules are not showing up or a NICEF? Should I ask for an email copy of the part rules? So look, do your due diligence, search every which way for the rules. If it turns out there are no rules, then find a phone number for Chambers, call up Chambers and say, I'm counsel on this case, this index number, and I've been trying to find the rules and I can't find this court's rules and I want to make sure I comply with them. Are they available or does the judge not have any? Some judges may not have individual rules. There's also local court rules. You need to check those. Local court rules for the court you're in, wherever it is in New York, as well as federal court. There are local rules. You want to check those. You want to obviously check the CPLR. You obviously want to check in federal court the rules of civil procedure, the federal rules of evidence. Follow the rules. We got to be rule followers. That's what we do as lawyers. We have to work within the rules. All right, Sophia, thank you for this question. She's asking if we could each share the best advice we received as a new attorney. Sally, I'll let you go if you have something.
Yeah, I said it before. Just keep your mouth closed in elevators and in court, hallways and lobbies. You just never know who's going to be there, and it's not worth the risk.
The best advice I got as a new attorney is be a man of your word and know that if something's done on a handshake, it's as good as written down and signed off. Yeah. Listen more than you talk. That's always good. That's hard for me. I talk a lot, but I also pride myself on trying to be a really good listener. All right, we still have a few more questions to get through before we continue on. But look, we're already into the second hour. We're cruising along. Thank you for staying with us, but it's not too bad, hopefully, for you so far, and trying to keep you guys awake while we get through it, and we will continue to do so. All right, Teresa is asking, can you file a pro se case through this link? I assume you mean through e-filing. I believe you can. You just have to check go onto that website, see if you have to log in. And as a lawyer, I'm not 100% positive. I think you can. And I think there's a method to do it if you're pro se. Okay. Yandy, can you give tips and tricks to get matters in expedited resolution calendars? That's because I understand how matters move in standard. I know what can be done to compel them in expedited. You work on estate litigation, including complex litigation therein. Well, by your term of complex litigation, that certainly doesn't help your argument to keep it on an expedited track and not a complex track, right? But I believe you have to have a good faith basis to say that it should be expedited. And I generally think that you should be entitled to a special preference for an expedited case. Like I mentioned earlier, I think, interestingly, medical malpractice will get a special trial preference, but they're considered a complex case. I believe if someone's over a certain age, over 70 years old, you could probably get a special preference. You may be able to ask for an expedited schedule if you can show it's a very narrow issue, or if time is of the essence. Let's say something has to be decided on your case before a certain date. So I'm not sure. I would certainly do a little homework on, what needs to be established to make it expedited, and then go from there.